These are appeals in the matter of Gatwick Investments Ltd and other Bath Racecourse Company Ltd and Liberty Mutual Insurance.
Morning, my lord. We're all the same as last week, except
You switch round.
we've switched round,
Fair enough.
and Mr. Walsh has had some good news, and will soon
We
be
gather.
King's Counsel. Congratulations.
Not
Not quite yet, no.
Not quite yet, but congratulations to you.
And your bundles have switched round as well.
Yes.
We'll find out how that works
Yep. Okay.
as we go. My lord, just to start with that, just the grounds that we have, we go to what should be a core bundle.
Yes. That's the furlough appeals call bundle.
Yes, I think that's right. So you should, what I think you have is 7 authorities bundles, a core bundle, and then some bundles that are case specific.
Bundle.
Yeah, that I think that's all.
Yeah.
My lord, just in the core bundle at tab 5, page 84. Your core bundle, I know my lord had taken it out anyway, your core bundle should have the judgment at the beginning in tab A, so the numbering sort of starts again at tab 1, but at page 84, tab 5, you see the 3 grounds, and Mr. Gruder and I have split them in the following way. I'll be doing grounds 1 and 3, and he'll be doing ground 2 afterwards. Our skeletons broadly split on that basis as well, although we do each cover each other's grounds a bit in the skeletons. My lord, the savings clause, before we get into the argument, I just thought I should show you those clauses again. So you'll need the Bath bundle, which is tab 7,
Yeah.
and you want page 112.
Yes.
I'm going to pass this a bit more later, but just so that we have it in mind, it's the savings clause, 2/3 of the way down. Charges or expenses payable cease or reduce in consequence of the damage, then you deduct them from the amount payable. And it's not disputed that damage here includes non-damage, i.e. includes our peril, which in this case is denial of access.
Well, there's no. It's common ground, isn't it? That whether it's damage or incident, the analysis is the
Yes.
same.
Exactly, my lord. Yeah, you're ahead of me. And my lord will recall that in the test case at both levels, it was necessary to read the machinery of adjustment so that damage included non-damage perils, because it must have been intended so to mean, including trends clauses and the like. And of course, it's my learned friend that relies on this clause. If we also just turn up the Gatwick. The Gatwick wording, which is at Gatwick bundle tab 6.
Yeah.
And it's at page 74. And it's on the right hand side, the paragraph.
It's part of the gross profit increase, including increased costs in working.
It is, yes.
Less any some say.
132.
Yeah, hang on, I'm going to.
Because there was a change.
Yeah, I'm going to come to that. So this is
some saved during the indemnity period in respect to the charges and expenses of the business pay without a gross profit.
exactly. So it's we say materially the same. It's some saved respective charges or expenses.
Yeah.
Here it's payable out of gross profit, and we'll come back to that.
And it's exactly the same wording in Starboard.
It's exactly the same in Starboard, but you'll see here this wording says not incurred or reduced instead of cease or reduce.
Yeah.
And as my lord said, it's incident rather than damage. But this wording was, and I think this is true also of Starboard, was amended at page 132 to a gross revenue basis by an endorsement. And you'll see the wording there, they don't need the wording about payable out of gross profit anymore. And it's gone,
Sorry, what, 122?
132, sorry my lord.
132, yeah.
It's halfway down, it's a gross revenue endorsement. And you'll see there's a less any sum saved. Here it's gone back, or it's gone to the same wording in terms of the cessation to cease and reduce. An incident for some reason has no capital I, but we say to the extent necessary that they mean the same and that there's no change between not incurred and ceased. And we rely on the one to interpret the other, and of course anyone with these policies without that endorsement would have not incurred or reduced.
What's the position of the Starboard?
I think it's exactly the same as Gatwick with endorsement. So that's the Starboard bundle, the endorsements at 1, 2, 3, and the standard wording is the same, liberty policy. The unamended, the pre-amended wording is at page 81 in the standard policy, but it's the same as the one we just looked at.
So it's my fault. I'm not in the Gatwick policy.
Yes.
So the endorsement we're looking at is at page 132. Is that right?
Yes.
Yeah.
The difference between that wording and the original wording is where?
At page 74, the original wording at page 74 said not incurred or are reduced, and the amended wording says cease or be reduced,
Sorry.
just like the Bath wording. So in the Gatwick bundle, you're looking at page 74 and page 132.
But in actual fact, we're only really looking at
132.
1, 2, 3 in the case of Starboard and 1, 3, 2 in the case of Gatwick, because it was amended from inception.
Yes.
Yeah.
So, well, the wages are the costs, and the two requirements in the clause, which we'll be exploring a bit later.
Yeah.
The first is that it's must cease or reduce. This is the cost or charge. Must cease or reduce, or under the previous wording, be not incurred. And ground one is that we say the reimbursement of the wages by the CJRS grant did not mean that the wages ceased or reduced, and they continued to be incurred. The second requirement is that, and that's if I'm wrong about that, as Mr. Justice Jacobs said that I was, if there was a cessation or a reduction, then was it in consequence of, those are the words in both policies, in consequence of the peril, i.e. the damage or incident, but in this case the peril, which is denial of access. And grounds 2 and 3 arise out of that. Ground 2 is a particular point that arose, especially in the Marrickville case, that the trigger for the CJRS doesn't correlate with the peril, and so the CJRS and the payments are not in consequence of the peril for that particular reason. Mr. Gruder will deal with that. Ground 3, which I'll come to at the end of the morning or this afternoon probably, is the argument that the receipt of the CJRS was not proximately caused by the peril because it was collateral. It was a collateral benefit. It was a gratuitous state grant equivalent in law to a gift. Now, grounds 2 and 3, and even to some extent 1, do interact, but we've seen fit to keep them separate in this way, and hopefully that will make it more clear than less clear, but we will see.
Ground 3 is an argument of construction, is it, of the clause?
Well, grounds 2, all 3 grounds are arguments of construction. 1 is what does cease or reduce mean, and 2 and 3 are what does in consequence of mean.
So it's a construction argument.
Yes.
It's not an argument as to the law in general.
Correct. We say, and we don't think it's disputed, that in consequence of here, like typically in these policies, including in the perils, means proximate cause, and therefore by that means it incorporates questions of proximate cause, but only because of the clause. My lord, just before we get to detail, I just want to set out our overall position on fairness and who has a windfall and this sort of thing. My lords might end up saying, well, that doesn't matter, I'm just construing the policy. Of course, that's right. But nevertheless, there's a big overarching policy implications, and also both sides say that the other side's result would be unfair and a windfall. So I just want to set out our position. It derives essentially from the purposes of business interruption insurance, which we quote in our skeleton, paragraph 87. So our skeleton will be in the core bundle. Tab 1, not to be mistaken for tab A.
Yeah, page.
And it's on the last, I think it's, the last page, page 27. Sorry, the penultimate page, page 27. And we quote, I just thought it was quicker to go here. In paragraph 87, we quote from Stonegate, and what we think is non-controversial. The purpose of business interruption insurance is to inject additional funds into a going concern to maintain it as a going concern. So this is what the insurers were paid to do by their premium under the contract. And it's not disputed here that the lost revenue that resulted from the pandemic and the restrictions fell within the scope of the indemnity. Quantification and proof is for another day, but it's accepted that the revenue that we lost was revenue as covered by this policy, and we'll come to the machinery in a moment. So had the insurers acted immediately to fund their insured lost revenue per the purpose of BII cover, subject to limits, etc., then the insured would have had the same profits as in a non-COVID year, same cash flow, and it would have kept its staff and paid their wages, and would have had no reason to make anyone redundant, because it would have been taking in the full amount of revenue it normally takes in just from the insurer. And there would have been no need for Bath or anyone else with such a policy to claim furlough at all, because it would have funded its expenses out of its normal revenue, which had been replaced. So what this means is the insurers, if they win on this point, they're benefiting from having delayed in paying, not criticising that delay. This isn't a question about interest, etc., but it's taken years, obviously, to work through these points.
So does this point depend upon whether the payment comes before or after the wage has been paid?
Well, no, because the point I'm making is one doesn't even need to claim furlough at all, because
So your point is that if the insurers had paid up, as it were, on the nail in April 2020, when the scheme was introduced by the Treasury direction, although it had been floated previously, but that's when it actually came into effect, your respective clients wouldn't have needed to participate in the scheme because they'd already been paid. Is that the point you're making?
They'd have been paid instantly in March and onwards as replacing their revenue. Now, of course, in practice, it takes time. But I'm just saying that the nature of the policy is...
Not knowing what the loss was at that stage.
No, indeed. It's a thought experiment that reveals that the policy is to cover the revenue, and with the revenue, then there's no trouble about paying the expenses. And it therefore follows that crediting the furlough payments here under the indemnity is a direct value transfer from the government to the insurers. Because without the grants on the insurer's approach, this is simple arithmetic and no one disputes this, without the grants, the insured would have been in the same position, but the insurers would have paid out more. So it's just a transfer of value, and the insurers seem to agree that in their skeleton at paragraph 62, this is in tab 3 of that bundle. At paragraph 62, that's bundle page 70, they don't really quibble with the point that the insurers are being subsidised by the government, and they make their windfall argument the other way. So, my lord, in the abstract, that doesn't mean a hell of a lot, and we will go through the construction. But you'll see that we say that a windfall really depends on, obviously, what the policy provides. But the premise of the insurer's argument essentially has to be this windfall is more important to them than to the insurers because of what we say is a strained construction that they rely upon. My lord, signposting. First, I'm going to talk about brief.
Speaking for myself,
Yes,
this means either a saving within the meaning of the clauses or it isn't.
Yes.
What the consequences of that are neither here nor there.
My lord, yes, and
Especially in the context of a commercial insurance policy.
you said a similar thing a week ago and obviously failed to listen. My lord, we're briefly going to talk about the grants, remind you of the grants terms and Bart's use of the grants. Then we'll be into ground one. We will look at the policy and its structure and what we say is the formula for the indemnity. And then we will move on to the savings clause in particular and how that applies to CGRS. And then such case law as we haven't covered yet by that point. My lord, under the first heading, the grant, I'm not going to go into the facts of COVID. I think the agreed facts were on your reading list in any case. They're recited in all of the judgments, some of which you would have read. On the scheme itself, rather than go to the agreed facts, I'm going to go to the Treasury direction itself, although that is summarised in those facts. That is at, I think it's in the Bath bundle. Tab 5, not tab 5, it's a bad start. Oh, it's probably B5.
What are we looking at?
What am I looking at?
What are we looking
B4, I think I'm at.
15th April 2020 Treasury Direction.
Treasury direction, exactly.
Yeah.
So it's page C16, it's numbered in tab B4.
Yeah.
And we first look at paragraphs 2.1 to 2.2 on page C18. We see, my lords will know this, the payments are made to the employers, not the employees, in respect of them incurring costs in respect of furloughed employees arising from the emergency. And then 2, they're only made in 2.2 by way of reimbursement of the expenditure in 8.1 that is incurred or to be incurred. So to state the obvious, the wages are still incurred and then reimbursed or funded in advance, which is the point my Lord Justice Popplewell adverted to. The Insurers skeleton, paragraph 6, which you don't need to go to, quoted Chancellor Sunak's speech, saying more colloquially that the government will help to pay people's wages. And then paragraph 2.4 provides that the payments must be returned if they can't be used for the single prescribed purpose. And paragraph 5 briefly identifies, we don't need to look at the detail, but identifies the costs that have to be incurred which can be claimed. The qualifying costs. And paragraph 6 defines the furloughed employees that they ceased work for reasons or circumstances relating to COVID. That's at 6.1c. Can skip, I think, paragraph 7. And in paragraph 8.1, you can see what is reimbursed. This is on page C24. It's the earnings, it's the national insurance, and it's an allowable pension contribution. 8.2 specifies that it's never more than 80% of salary and not more than £2,500 per month. So it's for the employer to fund the 20% if it wants to. And then page 31 points out that, not page 31, I think I'm on the wrong page, but there's it only runs up to May. Sorry, it's page 29, paragraph 12, but it was extended thereafter.
It was extended till about September 21, wasn't it?
My lord, and in materially the same terms. So
there were different Treasury directions, but they were, for present purposes, in the same terms.
yes, my lord. And then, if we also would just very briefly look at a speech of Mr. Sunak's statement, which is at tab 3.
Yeah. Well, it's set out in the judgment, isn't it?
Set out in the judgment, page 12, partway down says, today I can announce the government's going to step in and help pay people's wages. And it's described as a grant three times, I think. It's a CJRS grant to cover most of the wages. And then finally, on how the scheme works, at tab 7, it wasn't invoked here, but it's relevant to some of the argument later. You can see that there is guidance on how to pay the grants back later, voluntarily, and at trial there was some public evidence that some people are doing that. None of these clients have to date. We say that's relevant perhaps for a slightly obvious reason, that it highlights that the grant could be paid back, and if the grant's paid back and if the insurers are right, does that mean that the wages are unceased or unreduced back up to their original amount or re-incurred? It just highlights the separation between the grant itself and the wages that they fund in those cases temporarily. My lord, as to Bart's use of this scheme, if we go to, this is where we do need agreed facts, that's at tab B2. pages 159 to 160, so the end of that tab. You want paragraph 64 to 73. And the assumed facts at 65 to 68 make clear that in this case, we will come back to this when we look at the Stonegate decision, but in this case, Bath accounted for the payments, the grant payments, on a separate line as the expenses that they were funding or reimbursing. And the CJRS payments were accounted for as other income, and that was a mandatory approach if you're adopting the UK's FRS accounting standards, which these claimants, I think, were certainly Bath. We'll come back to accounting, as I say. Both parties say it's irrelevant, and then rely on it. My lord, paragraph 70 is worth noting. It notes, just in case my lord thought that it was only during lockdown. So 69 and 70, you see Bath claimants all applied for assistance up to August 21, and this included when the premises were open and operating to some extent, and when they were completely closed. Because even when they were trading, of course, even when spectators could attend, people were still dying and scared, and there were limited people attending racecourses, etc. And so it was often better not to make all your staff come to work. Oh, my lord, paragraph 71,
Yeah.
you'll see separate sums received. So for the Bath claimants, it totals around 6 million. And the parties agree that that would come off if it came off before you apply limits. It comes off when you're determining what the lost gross revenue net of savings is, and then you apply limits. So how much it's actually worth depends on various things, including last week.
Yeah.
Paragraph 72, that the scheme was complied with and the staff instructed not to work. And for Bath, in fact, I think it's in that paragraph, but in fact, all of it was by way of reimbursement. There was no funding beforehand. I don't know whether it matters, but as a matter of fact, no furlough was, grants were taken before the wages. And 73, that without it, they would have made some staff redundant. So, my lord, that's the facts, the Bath facts and the COVID facts and the CJRS facts, my lord. Turning to the policy structure, and I will take a little time on this because for us it's important. We go to the policy, which should now be at tab 7. We've seen much of this before. My lord, page 104 is the first overarching indemnity. At the top, indemnify the insured as follows. And to state the obvious, the indemnity in this policy and other business interruption policies is not an indemnity at large for loss. That's not what it says, and that's not what the machinery provides. So in that sense, it's not like common law tort or contract compensation. And it's also not like an insurance indemnity stated to be for actual loss, which some are. There's the Colex Australian case is referred to in some of the cases, and there they have an at-large indemnity. So it doesn't seek untrammeled to put the claimant in the position it would have been in but for the wrong. It has a formula that we'll address. And at page, you'll have seen before at page 57, that's the schedule, that we're on gross revenue basis rather than gross profit basis. And we now need to look, going back to the machinery, if we go to 107, I'd like to take you through the structure a little bit, my lords. So under gross revenue, which is basis B on page 107, you'll see there's an indemnity for the amount by which gross revenue falls short of standard gross revenue in consequence of damage. And there's a similar formula under rent receivable on the next page. And the definition of gross revenue is back at 104. It's money paid or payable to insured for work done and services provided in the course of the business. You may or may not think that that would include rent, but we can see that rent receivable is a separate. That's also defined on 105 and has a separate cover. And the standard gross revenue, standard rent receivable, which are on page 106, follow. So we know that this is about the reduction in the revenue that is paid or payable to the insured for work done and services provided. But it doesn't stop there, because if we go to page 111, we can see under interest and investment costs that the cover extends to include lost interest or investment income in financing developments, etc. So if you want to know what incomes the policy is going to take into account, both in terms of them having decreased, but also in terms of what actual revenues and incomes were earned in order to net the two off against each other, these are the incomes that are provided for. It's money for services that you earned and would have earned, it's rent receivable that you earned and would have earned, and it's the investment income. And if you did earn any as a result of the peril, then that obviously goes into the netting off to work out what is your reduction in gross revenue. And if Bath Racecourse starts selling horse racing t-shirts online and makes money from that, then those revenues will be taken into account because they're return for work or services. And in any case, you can see a form of that at page 110, where there's an alternative trading clause that clarifies or expands what revenue includes. Although this is all subject to a caveat on page 111, which is a departmental clause, which means that you assess reduction in gross revenue separately for each department if you have departments. So if one department makes loads of money, then it may have zero reduction in gross revenue, but it's
I mean, the classic example of alternative trading is where the premise is destroyed by fire.
Then you move to another
And
premises.
they rent alternative premises in order to carry on the business, but only to, as it were, to the extent of 50% of what they did previously.
Yes, absolutely, my lord. And then also finally on income, if my lords go to page 63, this is one of the conditions. And at the foot of the page, there's condition 21. Most of the things listed here are costs, but it seems to also include television rights income within gross revenue. And that would mean that that's another income that counts, if I may say so, for the purposes of working out the reduction in gross revenues.
Yeah.
is excluded from the otherwise defined revenues. And the cost we'll come back to in a moment. So even if it's revenue because it's income in return for services, it's excluded here from the indemnity formula. Now, government grants are income. Obviously, in fact, they're accounted for as other income. But they are not income within the formula of this policy. They're not revenue because they're not pay for services. And the defendants agree that, the insurers agree that, because they haven't argued that the furlough payments have to be taken into account as revenue. And this means that the insurers accept that other grants, such as hardship grants, which are not linked to any particular expense, this arises here because CJRS is obviously linked to the particular expense of wages, but a general grant, and there were COVID hardship grants, are not revenue or any other income to be taken into account, nor is there any way of fitting them within the savings clause. And so it follows that where, as a result of the insured peril, insureds receive COVID hardship grants from the government, as well as charity and any other incomes not within the definition of revenue, then they can keep them without any reduction in the indemnity. Now, is that a windfall? As my Lord Chancellor said, it's not really a relevant question because it's only a windfall in the sense that with hindsight, one party doesn't like the terms it's
Well, the
agreed.
hardship grant does not on any view equate to a cost being ceased or reduced.
Absolutely, my Lord.
Or a charge being ceased or reduced.
The point that I'm making, perhaps obtusely, is that revenues and incomes are dealt with by one half of the equation. We'll come to the cost side. And we say that wherever money comes in, and it could be reimbursement or funding, it's an income, and you have to work out whether that income is covered by the policy, and that the insurers fully accept that where a grant is received, it is not income, so it does not fall within the insured incomes to the business. And so it's therefore not part of the insured revenues, and that cuts both ways. If you receive a lot of grant income in your normal business, then if that grant income tails off as a result of a peril, well, you've got no cover for that. Unless, so if I would just briefly show you in the Authorities Bundle 3, tab 49, not tab 49, tab 40, page 1060, so I think it's right at the end of that tab. The final paragraph, following the penultimate paragraph of page 1060, it's not a particularly interesting point. It just highlights that some businesses that depend upon grants will include grants as an insured revenue.
Sorry, Michael, what page are we on?
1060, the very final sentence explains that for some businesses, particularly those that in this context get research and development grants, would want to insure that income and pay premium on it. And if they did that, the position would be very different. You get to choose what incomes you're insuring. So as I was halfway through saying it cuts both ways. If you previously rely on a lot of grant income and it tails off because of a peril, under the policy that Bath has, you have no cover for that. But equally, if you earn more grant income as a result of the peril, then that also doesn't get taken into account by virtue of the nature of the machinery, which defines reduction in gross revenue, which means working out what the total gross revenue was before and what it is now. So,
Well, doesn't it all depend on the nature of the grant income? If the furlough scheme had operated to be payable directly to employees, then it would come within this savings clause, wouldn't it?
it wouldn't be a grant income, it would just be wages that hadn't been incurred. It's a bit like the Lowick Rose point, which we'll come to later.
You're treating all grant income as though it's a category of itself. We come back to the point.
Well, my lord,
it all depends on the wording of the particular clause and the nature of the
nature of
the grant, doesn't it?
always it depends on the clause, but it doesn't depend on the nature of the grant income, because what I'm trying to show you, my lord, is that the formula under the policy assesses income and it assesses costs, and we'll come to costs in a moment. And no grant income is within the insured income. And we say the consequences of that can go both ways. You could have, there used to be 25 dog tracks within the M25, and now there are 2, I'm told. It could be the case that the local authority grants are regularly paid to Bath racecourses because they're culturally important and they want to be supported. And then when COVID hits, they're stopped because no races are run. And Bath racecourses couldn't claim in relation to that because it's not a covered income. And we say that that's just the flip side of the point we're making here, which is characterising any grant paid to Bath racecourses as a cost saving is looking at the wrong part of the policy. It's to support the construction argument more generally, which we'll come to in a moment.
I wonder if there's a false premise in your... If a business has grant income before any interruption, then it has grant income, and if it loses that grant income, that may or may not, you say not under the terms of this policy, go into its primary measure of a loss. But why does that determine whether a grant which is as a result of the insured peril, we're assuming for the purposes of this argument, why does that determine whether that grant constitutes a saving within the clause? I just don't see the equivalence between the two.
It merely
It's not a loss of grant income, it's new grant income.
Which didn't have before. Didn't have it before.
You didn't have it before. My lord, if we imagine that grant income was included
Included in what?
in the definition of turnover revenue. So let's assume that was a covered income, and therefore the insurers would have no problem arguing that the grant income subject to causation has to be taken into account, because when you're calculating your net reduction in revenue, you have to include all the revenue
No, but
that you have.
that's looking at lost grant income.
No, my lord.
We're concerned with new grant income.
Let's assume that the policy covers lost grant income.
Yes.
And then in this case, new grant income is received. That obviously has to go into the reduction in turnover calculation, because you've got to measure your actual revenue, which includes the fact that you took in grant income.
Not necessarily. It depends whether the nature of the grant income is the same as defined in the clause. Does it?
My lord, yes, let's...
I'm not finding it very
Same as
helpful
the
myself
grant income they've had previously.
to describe things as grant income and then to equiparate lost grant income with new grant income.
I mean, if it were, I don't know if it was the
Same
case or not, but I mean, if it were the case that some of the these arena racecourses were actually subsidised by the local authorities by way of some grant or other, and that ceased when COVID came along. That's a completely different creature from the furlough payments, which only come about because of COVID.
They did, my lord, and
The other ones have got nothing to do with COVID. They're never being paid as a result of any sort of insured peril in the first place.
well, my lord, I'm just.
I'd actually be rather surprised whether any local authorities were funding racecourses, but
No, it was a hypothetical.
I know it was hypothetical.
Yes.
It's just
Walthamstow closed, so maybe that's why.
maybe one or two of them.
My lord, yes, I'm sure they don't have money for that.
Foss Lass, for example, which is right at the far western part of Wales.
My lord's
So I had
more
to declare
knowledgeable
an
than I
interest
am.
because I had a share in an extremely unsuccessful racehorse.
My lord should have declared that at the outset, but I don't think it was.
It's just been sold.
My lord, the point I was making, stroke labouring, was merely that there's a structure to the policy, and of course one can hypothesise all sorts of things. But if one hypothesises, and I'll run at it only one more time before I move to the cost side of the equation, if one hypothesises that the revenue included public grants, for whatever reason, probably because there were some, these grants would then fall into that and would fall to be calculated against the reduction in revenue. But the insurers say they would also mean that the wages ceased. So they would get a double cover. And we say all that highlights, it's just an example, but all it highlights is that there's one place in the policy where you expect incomes to be if they're covered. And that's the definition of revenue, and not the other side of the equation, which we'll come to now, which is costs. So if we go to page 107 of that Bath bundle,
Yeah.
we've got, there's familiar territory here, my lord. We were there a moment ago, but now we see that on the cost side, there's increased cost of working. So that deals with any increased costs, and page 108 to 9 also have increased cost of working, additional increased cost of working items. So where the costs have gone up for the purposes of trying to reduce the revenue loss or make up more revenue, that increases the indemnity. And then you've got page 111, we looked at the interest investment costs. That also includes a provision for additional interest incurred, not just investment income lost. So on the cost side, there's a provision to cover a particular cost as a result of the peril. And then page 64, which you haven't looked at before.
Yeah.
Condition 27 tells us that you can cover costs that were maintaining your reputation.
Yeah.
And then we have the savings clause at 112, which says that any charges or expenses that would have been payable but are not payable are taken into account. So on the cost side, the indemnity doesn't just take into account increases in costs, such as increased cost of working, but also reduced costs due to the peril, which are the savings. And the word charges here must broadly mean costs, although it's a term that has a flavour of emphasising the incurable. It's used also, for example, on page 110 in accountants' charges. That's charges payable, and 111 in hired in plant, hire charges. And if anything, we think, sorry, also the foot, it's under outstanding balances. So the charges, we say, are obviously emphasising the relationship between the payee and the insured. Are they charging? Is there a levy? Is a liability incurred? Is a payment made? Now, the examples of charges that to date have engaged the savings clause are obvious things like electricity costs reduce when your factory's burnt down. And maybe it's relevant later anyway, maybe worth looking at the Polikoff case briefly. That's at Authorities tab 1. Sorry, not tab 10. Authorities 1, tab 10. Yeah, sorry, that's mine.
Yeah. This is Justice Branson's case.
My lord, yes, Miss Justice Branson. It's a fire at some premises of Hackney clothing makers and retailers. Business interruption claim. Some mortgage interest charges, which were one of the specified standing charges, were reduced, so there was a saving. And the controversy was the reason for that. The reason the mortgage interest charge is reduced was because the insured used an insurance payout from a different policy, material damage policy, to pay down its insurance. And if you see it, page 67, where it says on the right hand side there's the clause that starts provided in the bottom part of A. That's the clause. Standing charges shall be reduced or cease to be paid. And just to touch on the approach as well, if you go to page 71, left hand side, you'll see now the next point says near the top, said, well, it provides for a reduction in standing charges, but what if they increase? And the answer in the second paragraph, I think, was that it's tough luck. If the standing charges increase, then they can't be claimed for because the clause doesn't say anything about that. And it's in the second main paragraph. I think there's no doubt. And halfway down, after all, one has to remember that it just emphasises that the parties have their formula, and that's that. And then at page 73, left-hand side, we have then the next point goes over to the down the page and over to the top of the right-hand column. And it's a non-point for ground 1, and it's a non-point even for ground 3, because the point made there was, well, even though I might want to disregard this saving because it was collateral, because it was to do with the way the insured chose to pay down its mortgage using insurance payments, the words don't allow me to, and we'll later see that the words in consequence of were added to the savings clause to deal with that. So that case and all other cases, and we'll come to synergy in one moment, which is the furthest step taken, but all cases relate to charges that have ceased to be paid, full stop. No reimbursement, no funding. There's never been a case before this one where anyone has suggested in case law or commentary that a savings clause covers a charge that's still incurred but where a source of funding is secured to match it. The synergy case is at tab 24. It's a decision of a promising High Court judge. Quite a
I have to accept I might have got it wrong.
maybe, but we don't need to say that, certainly, because it's about depreciation. We do understand that my lord, from someone who's in the case, that my lord gave permission to appeal, but that wasn't pursued.
Yeah, I'm wondering about that, curiously. I did sort of vaguely remember.
Maybe my lord got away with it.
Maybe.
It was a fire at a laundry, and the held note number 4 shows you that actually that there were some avoidance arguments. They failed for lack of inducement.
Yeah.
Held number 6, which is on page 305 of the bundle, deals with the indemnity calculation. And then if we go to page 339, on the right-hand side, in paragraph 240, at the bottom of that quotation, one can see the savings clause, less any sum saved. So,
Less any sum saved during the indemnity period.
yes, material identical to our words. And at paragraph 241, my lord can see that there was an increased cost of working of 2.85 million. And we're concerned with the second issue on the indemnity, which is at paragraph 251.
Yeah.
And it's that there was a depreciation charge that ceased to be made because the machinery was destroyed. And then there's the conclusion at paragraph 253 that the deduction ceased to be made, and that was a saving. Paragraphs 254 to 5 are principally textual points about depreciation in this policy, so don't concern us. Although under 255, I would note that there's a point that my lord relies on, that the definition of gross profit contemplated depreciation. And then at 257 is about whether the word payable would include, so is this charge of depreciation payable out of gross profit? Is that supposed to limit the charges to only those that are financial outflows? And my lord says it probably wasn't meant in that technical sense. And at 258, that this construction stretches the word payable somewhat. But at 259, that the contrary conclusion is unreasonable. And at 260, that payable nevertheless definitely can include depreciation as one of its natural meanings, and that the accountant's understanding is not very important. This decision was relied on in some of the CJRS deduction decisions, which we'll come to. So I should probably set out our stance on it now, which is that synergy, first, it's not a decision about the meaning of cease or reduce or not incurred. That part of it was not being debated, because there the cessation was clear. And the dispute was whether it was a charge payable out of gross profits. Secondly, obviously, synergy was not a decision about whether an income that sets off a cost means that the cost ceased or reduced. And therefore, thirdly, we have no dispute as the outcome. We don't have a view on depreciation. I don't need to go to it, I don't think, but there's a section of Riley in the authorities bundle. For the record, it's at authorities 3, tab 49, 1269. Riley spends 4 pages explaining that the market is a bit undecided about this, and parties often include words to provide for it, and that synergy goes one way and there's an Australian case, Mobis, that goes another way.
Yeah,
We don't care about that because we're not dealing with depreciation.
Yeah.
But moreover, depreciation is on no view, and I heard the resistance, or perhaps that I'd failed to be clear enough on my explanations to the structure point. But in any case, depreciation doesn't engage that point because it's not about an income at all. It's just about a charge and whether charge means something narrower than was ultimately held. So we also, therefore, this might be fourthly, or I might have lost count, we resist any suggestion, though, that all the terms of the savings clause should be stretched or strained as a general matter in order to achieve a full indemnity. We say this is just an ordinary exercise of construction, and that the question is what the parties meant, which is the exercise that my lord went through there, looking at the words and commerciality, etc. And we suggest that each question of construction should be dealt with on its merits, and you just have to find the objective meaning of the language which the parties have chosen to express, to use the terms from Will and Capita. But perhaps it's not the fault of my lord, but that approach of whether one strains for an indemnity or doesn't has become something of a topic for intense discussion in some of the case law. And we say that my lord wasn't mandating any general straining. Of course, in our law of commercial contract construction generally, we're moving away from straining, and whilst once upon a time exclusion clauses were strained, now that only really happens where the clause robs the underlying obligation of all substantive purpose and content, which is clearly not the case here. The insurers don't say that without their construction the savings clause means nothing, because of course it means all the obvious things that we think it means, which is it covers a reduction in electricity charges and wages, etc. So just to deal briefly with how the variable costs type issue works, how costs are interacting with revenue, because of course these policies very much do consider that question. Typically, where you have variable costs that will always be saved if your factory burns down, it's of course common to insure on a gross profit basis, because you then insure the lower amount rather than insuring all of your revenue and then paying the premium on that, but nevertheless always providing savings for the variable costs that were saved, that were no longer incurred. And in our policy there is provision for uninsured variable costs and gross profit, but we're on a gross revenue basis, subject to one point that I'll make in a minute. But either way, what the parties are doing is their own netting. So the policy provides for a netting. It provides for a netting off of changes in income against changes in costs, and it provides which costs get netted off and which incomes they're netted off against. And the clause that I showed you before, which is condition 21 at page 63, although this is a gross revenue basis, condition 21 in effect makes it a sort of gross profit policy because it excludes certain costs from the analysis. And indeed the placement spreadsheet, which I still haven't shown you because I don't think I need to, but it's the one I referred to last week, which has the different lines for the different premises, makes clear that the revenue figures exclude these costs, so they've been reduced to take out the amount of these costs because these have become uninsured costs, and the revenue reduced accordingly to reduce the premium. And that's the netting that the parties have chosen. Other variable costs that reduce get allowed for under the savings clause. Now, going back to that clause, so it's page 112. We're into more standard, gone through the words territory here, and we say that the words cease or reduce have clear meanings. There are dictionaries in the bundle at Authorities 340, tab 48, but they don't say anything other than what you would think, that cease means stop and reduce means diminish. And here you've seen that they cover costs that would have been incurred and are not, so that's wage costs or energy costs or depreciation. And indeed, one of the government's reliefs was business rates relief. And there's no argument from me that that was a cessation or reduction, because what happened was the business rates did not have to be paid. They weren't incurred. The outgoing to HMRC ceased or reduced in relation to those business rates. Less money was sent from the one to the other. Now, although I might argue, if that were this case, that it's not in consequence of the peril, that's a separate question. It definitely was a cessation or a reduction of an expense, which was business rates. And we say, you can stare at these words all you like, they do not include someone stepping in to help you pay a cost, a charge or expense. It's just not in the words. So reimbursement, which is a different thing, it involves money coming into you.
If the government had paid the employees direct,
Yes,
then the employers
there'd be a cessation or reduction.
ceased or
Yes.
reduced.
Absolutely, my lord, and we'd still have the consequence of argument, but
I understand that.
absolutely, completely.
So the argument turns upon the form of the furlough grants rather than the substance of them.
It turns on the
Is that fair?
it turns on the character of the impact on the expense.
Yes, I now understand your argument on the wording of the clause, but
Yes.
the substance of the furlough scheme would have been the same, with the same purpose, had the government chosen to say, we will pay the employees direct 80%, and you can amend your contracts of employment so that you're only, you the employer, are only liable to pay the 20%.
They could have done. Obviously, what actually happened is the government was giving the employers a choice as to whether to furlough employees or not. But it could, this payment mechanism could have worked direct to the employees. And I'll come to why that shouldn't trouble you. My lord uses the word form. But the nature of this formula is it's a formula about form. It's about what is an income, what is a cost, is it that type of cost, etc. And the fact is that the insurers may regret the way that the government did what it did. With business rates relief, the insured could say, well, it's a shame they gave us a relief rather than paying us money to pay the business rates. But that's what they did, and this clause provides, it's a blunt tool in a sense, but it provides for cessation or reduction because of what it contemplates, which is bills going down. And in this novel situation, there's no license, we say, for reading in some sort of overall commerciality that, well, if someone was willing to give you income, give you funding or reimbursement to match that cost, that counts as a cessation or a reduction.
Do you say that no form of reimbursement would amount to a cessation or reduction?
Yes, my lord.
So,
Well, I haven't thought of another example, but my lord's about to put one.
Well, say that an insured is struggling to pay the rent for premises, and the landlord, if the landlord reduces the rent going forward, that's plainly a reduction or a cessation. But if they say, well, in fact, we will give you a rebate or reimbursement in relation to rent already paid.
Sorry, my lord. No, I see what my lord's saying. No, if the reimbursement is of the payment by the payee, then that's another matter, because overall one can say, well, the charge was reduced because it came back, it wasn't paid.
This scheme is described as reimbursement.
Yes. But not by the employee, obviously.
Why does that matter?
Well, if the electricity supplier charges me and then later it says, oh, we overcharged you and it pays me money back, then it's reversed the charge. So of course that's to be taken into account, and I can't say no, neither party can rely on the initial charge because the charge has been reversed or amended as between the payee and the payer. But if a third party comes in and funds something, it's not reimbursement in the technical sense of it's not being reimbursed by the payee, it's obviously by a third party.
No, but effectively what the government is doing is reimbursing the wages effectively on behalf of the employee, because the employee isn't providing the service. And it's a retention policy, so rather than what it's saying is, well, we appreciate that if you're incurring these wages in full without any reimbursement, you're probably going to make a lot of these employees redundant.
Yes.
Or otherwise discharge them. So what we're doing is we're paying you back the wages that you have paid or will pay. And effectively the government's doing is reimbursing it on behalf of the employee.
My lord, the final step that they're reimbursing you on behalf of the employer, there's no license for that. What they're doing is they're funding the business, but rather than funding the business generally and saying, well, we know businesses are in trouble, they're providing a reward scheme. They're basically funding the business to try to incentivize the business to retain the employee who is doing no work. My lord is right. But there's nothing in that structure or what was said to say that they're reimbursing on behalf of the employee in any way. Otherwise, you might think, well, they would just pay the employee. What they're doing is they're paying the employer if the employer is willing to keep the employee on. But they're not providing any...
As I said, it could have been done by paying the employee. Instead, it's not. It's described as a reimbursement to the employer. And it's specifically designed as an 80% of the amount that was to be or had been
Yes.
paid. So it's directly linked to the amount. It seems to me it's directly akin to the reimbursement of rent, isn't it? Only the fact it's being paid by a third party you're being reimbursed the salary.
But it's not, in no sense does it come from or on behalf of the employee. There's no logic for that. The employee obviously is substantively intended to retain the wages and does do so, but provides no service. You're paying someone else's wages. So it's a funding.
This becomes extremely semantic, doesn't it? Because the reality of it at the end of the day is that the government paid 80% of the employee's wages. Not the employer. That was how it was advertised. That's the reality. And to say that your client still paid 80% of the wages is to ignore the commercial reality of the situation.
Well, depends what one means. This commercial reality is a bit of a bootstrap issue, because here we're talking about cessation or reduction of an expense, and here the expense necessarily continued and was incurred. So my lord might be saying whoever drafted this savings clause is a fool, because they should allow for the situation where the expense remains to be incurred, but for commercial reasons becomes neutral to the insured because they're funded. And one could draft that, and maybe insurers will from now on. But the clause says what it says, and whereas if a charge is reversed by the payee, well, clearly it's not incurred in that situation because one has to go with the overall charge, and you're dealing with the relation between the payer and the payee. That's just a very different situation. As perhaps if we could,
Well, the only question is, isn't it, is whether on a purposive construction in the commercial context does reduce encompass a situation where the government pays 80% of the wage bill.
yes,
That's the only question.
that's the only question. Equally,
One might say
And I
that
say the effect, it might be said that the effect of the government doing that is that the expenses of the business have at the very least reduced. Overall, at the end of the day, the expenses of the business are reduced. I mean, true it is, if you look at a snapshot at the moment where the employer carries on paying the employee, you could say, well, there's no reduction because I'm still paying the employee. But the reality is that the government then reimburses that payment, as a consequence of which the overall expense of the business has ceased or reduced. We're probably in reduced territory rather than ceased because it was 80%. I mean, that's essentially the argument against you.
the argument is that the word that reduced, an expense reduces if another income offsets it.
Well, it's not. It's not really another income. It's a payment by the government specifically in respect of the wages of the employee.
it reduces it by 80% because
Yeah.
it is specifically designed to reduce it by 80%. That's exactly what this was designed to do, induce employers' cost of employing their staff by 80%.
It's reducing, it reduces their overall netted off financial position. So the insured doesn't need to worry in terms of its profits, etc. It doesn't need to worry about funding that 80%, and it knows that when it comes to the preparing its accounts,
It was, forgive me, it wasn't, maybe the overall it was to do such things, but it was a targeted payment of 80% of the employer's employment cost. Simple.
absolutely.
So was that a reduction of the employer's employment costs? Looking at this.
Yes. What if?
That's the only question.
Let me come at it another way. If we look at, can we look at the Swinson case in the it's not an insurance case, but I just want to show you the question of form. We go to the Furlough Authorities 2, tab 26. My lord, it's a claim, it's a professional negligence claim against some accountants in relation to 3 loans that the claimant made induced by that accountant negligence, and the borrower wasn't good for the money, hence the loss. But for commercial reasons, perhaps poorly advised, the owner of the claimant loaned money to the borrower, who then was able to repay 2 of the loans. And the claimant sought to claim nevertheless for those loans that had been repaid, saying, well, they were funded by our owner and that's collateral and res inter alios acta. And the claimant failed because the loans had been repaid. And if we go to paragraph 48, my Lord Justice Longmore, in the Court of Appeal, fell into the error that with respect I suggest my lords may be in danger of falling into. Which was to say, well, if the owner had just given the money to the lender, then that obviously wouldn't have affected damages. Just because it gave the money to the borrower and the borrower repaid the loans, why should that make a difference? And Lord Justice Longmore said, will it be a triumph of form over substance if it would be a different result, just because the payment's made through the borrower?
This wasn't a question of construction, was it?
No, my lord, no, absolutely not. And there was no cease or
It's
reduce.
a question whether it was a collateral
Absolutely.
benefit. And that's a different question.
It is, that's my ground 3.
Here is whether or not we are constrained to read reduce so as to exclude a situation where a payment by the government, mainly designed to reduce employees' employment costs, isn't a reduction. In other words, we're being constrained to find that the commercial reality and the intended purpose of these payments does not coincide with the word reduction, reduce, in this clause.
Well, my lord says they were intended to reduce the payments, but that's my lord's word. They were intended to reimburse the payments, to fund the payments. Whereas the policy says cease or reduce.
So that employers wouldn't otherwise reduce their wages bill by terminating the
Correct.
employer's contract.
Yeah.
But
Obviously,
we're
the,
in the work, but we're looking at commercial contracts here. We're not, forgive me, we're a million miles away from what Lord Mance is considering here.
we're looking at a commercial contract, but the point is that where there's a world of difference commercially, and therefore for the implications for the legal causation question in Swinson, between a debt actually being repaid and the debt not being repaid, but an offsetting about being paid to the lender. And we say, well, there's similarly a world of difference between a cost ceasing or reducing. It may be form, but these are the words the parties have chosen, and a cost being funded by another party. There's no license equally to look at the word revenue and say in the turnover provision and say, well, you did earn that, but it was deliberately directly linked to a particular cost. So I've got to commercially, I don't think you actually did earn that income because it was already earmarked for a cost. They're separate concepts, and you need to look at the one or the other. There's no other terms where you would commercially, within a financial formula, and business interruption policies are notoriously difficult because often you have lots of loss adjuster arguments about exactly what is payable out of gross profit and how these things work. And they're deliberately set up to provide a mechanism which obviously in this case has failed to avoid argument because of the novel facts. But that's what's intended to happen, and for better or worse, which is the nature of all construction, the parties have agreed that they have a savings clause where their charges cease or reduce. They do not talk about income or revenue, which is a term used elsewhere in the policy. They're talking only about the costs or expenses. And the structure provided by the government, and I showed you the Treasury direction, expressly maintains that the expense has to continue to be incurred. That's actually the condition of paying the CJRS payments.
But does it remain a charge of the business if it's reimbursed? If we're looking at the construction of the clause, we have to ask, well, what is it that has to cease or reduce? Your case, as I understand it, is the legal obligation to pay the wages to the employee, and they never cease or reduce. The employer maintains that legal obligation in the full 100%, and that is the expense or charge of the business that has to cease or reduce, and it doesn't. The case against you, as I understand it, is that if you look at the wage bill as the charge on the business, i.e. how is the business affected by the wage bill? The answer is that the wage bill has reduced, and that's what's meant by a reduction in the charge of the business in relation to these wages. Now that's,
But it hasn't reduced, my lord.
well, it has.
The wage bill is literally the same as it was before, or 80%.
The wage bill as a charge on the business, that is to say, the extent to which the wage bill affects the business does change.
My lord, that's a strange, if I may say, an unusual definition of charge, because
In the context of this clause, that's,
we've agreed
that's
it's
what
funded.
It's all about how the potential saving affects the business, doesn't it?
I might have an expense, and in this case, the expense continues. The employee still charges me, I'm doing a PAYE scheme, but effectively charges me the wage, and I pay the wage, and the wage actually leaves my account. That is the charge. I may be able to get a group company to agree to fund me that charge because for whatever reason, survival maybe. I might get a loan that exactly matches that charge. But you wouldn't say that charge has been replaced with just the interest cost on the loan, because I've still got the charge. I happen to have funded it. We always fund it. You would fund it with revenue, but the revenue remains revenue and the charge remains the charge. So,
Can I just try another example?
Yes, my lord.
Suppose the employee says, I don't want you to be taking the government money. You've paid me the wages, I've still got a contract, but I'm voluntarily going to pay the money back to you. So the legal obligation of the employer
yes.
has not ceased or reduced, but the actual amount that is paid does cease or reduce. Is that a saving within the clause?
The employee chooses to repay its wages. I expect so.
So the clause is concerned not with legal obligation to pay, but the practical effect.
It's concerned with where the money went. Did the money go out or not to that person? Yes, that's a charge. And if it was reversed, even if there was no legal obligation, if the electricity board decides we've decided to rebate everybody because you're all going through a tough time, we have no obligation, then we would say, well, the electricity charge has reduced.
But if that's right, why do you say that the clause is concerned with the legal obligation to pay only?
Because the concept of charge and expense in all senses, including the accounting sense, is fully able to engage with any permutations between the payer and the payee. That's the natural meaning of charge. If I go into a shop and they say, well, how much will you charge? And I'll say £100. We'll say, well, hang on, he gave you £20 back at the end. Well, I was only charged £80. That's very different on the matter of English, accounting and commerce to how much will you charge? £80. No, you weren't. Your brother gave you the money.
What you accepted a little while ago that if the government had paid the employees direct, then they'd be within the savings. The employer would be within the savings clause.
Yes, ma'am.
Do you also accept they'd be within the savings clause if, in the scenario where they've been paid the wages, the government gives the employees the same amount of money for the employees to reimburse the employer? Picking up on my lord's point that the employee says, I don't want the money anymore, have it back.
Mm-hmm.
It's a situation where the government is now saying, here employee, you have your wage, the equivalent of your wages, give it back to the employer, and the employee does that. That would be within the savings clause, wouldn't it?
Yes, because it's ceased or reduced, and yeah, yes, my lord. My lord.
But what has ceased or reduced? Not the obligation to pay the employees,
The charge,
but simply
the expense,
simply
The bottom line.
the
at the end
bottom
of the
line,
day.
the net position.
But there's no
even if
netting.
paid in the first place.
There's no netting. It's just the position between the payer and the payee.
Yes, but the position between the payer and the payee is that the payer has initially paid,
My lord.
and the payee has paid back.
Yes.
And it wouldn't matter where the payee got that money from, whether it's the employee's grandmother or the government or whatever. What you say makes all the difference in this case. is that the mechanism is that the third party reimburser, in this case the government, makes the payment to the employer rather than to the employee. You say that makes all the difference.
It
under
makes
this
all
clause.
it makes all the difference in the world as to why when I went into the shop, if my brother gave me the money or I borrowed it, nevertheless, the exact amount of money, maybe it's even an amount of money that is, it's a loan that can only be applied, like a student loan has to go to a particular expense. Let's say there's a buying a particular thing loan or an electricity charges loan. And the fund to me, the loan, or the gift, provides the exact amount of the expense. So in the overall transaction, one might say, well, commercially, it was neutral to you because you happily had an income at exactly the same time in the same amount. But this clause, we say, doesn't give license to investigate those things. It doesn't ask you to ordinarily look at whether you got money from any source, whether it be revenue or any other source, and say, well, commercially overall, are you in profit or not? Why? Because there's a mechanism for that, and it's the actual provision of insured gross profit. So here, take the revenue. How does it differ from standard revenue? Take the savings, which is how your costs differed. What are your increased costs? That's the netting that's licensed. And what you can't then do is net within each concept, because then you're blowing up your definitions. You're saying, but income also counts if it nets off an expense. And indeed, expenses also count if they net off a revenue. I would say you haven't earned that revenue anymore because it's attributed to an expense. But that's not the way it works. The revenue question is just looking at the revenue figure. My lord, there's always a danger that one needs to look at some law, so I think we should probably look at the cases that have considered this.
Yeah.
Authorities tab 7. I'm going to start with the most recent, although not only for that reason.
Bundle 7.
Sorry, bundle 7. And the back of bundle 7, there's a D1.
Yeah.
My lord, it's the Supreme Court of Victoria, as recently as about, well, less than a year ago, judgment in June. As my lord says, this is the first instance commercial court. And it postdates our skeleton, so it's not referred to in them, but it is on your reading list, so you may have seen it. My lord, if we go forward to 16, it's a COVID case. If we go forward to 1631, that's the page. There are a number of other issues being considered. And
Sorry,
1631.
Yeah.
And we see at paragraph 438 that the insurer's quantum, I think loss adjuster or quantum expert, has said he's deducted JobKeeper payments because actual head office expenses have been reduced by the amount of the payments received, as it was effectively covered by the payments. He might have been listening to my lord's conversation only moments ago. And at paragraph 440, there's a reference to the accounting position, which is the same as ours, that the grant income was treated as other income. But they funded wages.
Yeah.
And then at 1633, you'll see 442, which summarizes JobKeeper. I don't think we need to look at the detail of that, but it was payable to employers suffering a turnover drop to pay their eligible employees a certain amount. It's not identical to our scheme. It's not vastly dissimilar, at least for the purposes of round 1. And then the explanatory memorandum, which is on the next page, is summarised, and not dissimilar to our situation, it enables employers to continue paying employees. And then paragraph 448, if we jump forward, is the question of whether the JobKeeper's amount give rise to a sum saved in respect of such charges as may cease or be reduced. So our wording. And there's then a summary at 451 to 2 of the Marrickville decision, which may avoid me having to go to it. So if we just look briefly at that, I might have to look at one respect, but you'll see that at first instance in 451, it was accepted that the JobKeeper was a sum saved by at first instance. And then at 452, that the full court took a different view, and most especially they did so on the basis that's our ground 2, which Mr. Gruder will be addressing. And that's summarised at 453. And the full court didn't address the cease or reduce question, although they allowed the appeal on the ground 2 point about what I've called correlation. And then at 455, the insurer there, as in all of these cases, relies on the general indemnity principle. And agreeing with the full court in Marrickville, the judge here, Justice Osborne, I think it was, says that I prefer not to rely on such reasoning about leaning towards a general indemnity principle because the policy provides the terms and the formula. And then 457.
Any policy that has
Yeah.
a formula may end up overcompensating the insured, or it may end up undercompensating the insured, if that's what the contract provides for.
My lord, yes, and I remind you that there are lots of COVID grants that don't fall within revenue or savings clause, and therefore that's the consequence. And the parties have agreed that. So there's no need to strain to assume some sort of full indemnity because that's not the way the machinery works. 457 considers the Mobis case. My lord just skims through that and through 458 to 9. And that was essentially an agreement with that point that you won't get a full indemnity, so don't construe to achieve one.
Well, that's the point I just made.
That's the point my lord just made. And 460 is largely to that point. It's a quotation from Mobis, and in the middle the quotation from Mobis includes a quotation from Henry Booth, the English case where Justice Greer said the same thing about it's always just a formula. And in Mobis, it was determined that Mr. Justice Flo went too far in Synergy Health when or if you read that case as imposing a presumption towards full indemnification. We suggest that Synergy doesn't have to be read that way, but it has been used that way by insurers in arguments, and that was rejected there. Of course, those were both the depreciation decisions, so it was very important that Mobis addressed Synergy. And then at 461, they distinguish Colex, and that's the one I mentioned briefly earlier. If you see at 463, that the Colex indemnity unusually is an indemnity for actual loss of gross profit, but with a not exceeding provision. So you have to look at actual loss, which is a different and less restricted situation. And 463 in the second half just says, well, let's just construe the savings clause, and that's what happens at 464 onwards. And this judge prefers to look at the cease or reduce point rather than the in consequence of point, and does that at 466. Which says that the very purpose of the grants was to ensure that the wages did not reduce, and that everything must follow from that, which is, as my lords would have discerned, what we say. So we rely on that decision, but more than that, we rely on the reasoning in that decision as resisting the more complicated, and we say strained, approach of saying, well, a charge, even though the purpose was to maintain the charge and to keep you paying the employee, because you were funded to do so, the charge is reduced to the business in some way. And we say, no, that's not what the words say. The wages were maintained, and that was the very purpose of the CJRS. My lord, the first reported case in England on this was Stonegate. I'm bound to say that before that, it's public that there was an arbitration award of Lord Sir Stephen Tomlinson and Richard Akins that found furlough and business rates relief were not to be deducted, but the actual award was never made public, and the case then settled. So I can't rely on any reasoning in that case, although there is an Insurance Post article that I could show you if you wanted. That's not going to help you very much, because there's no reasoning. But it's not a disputed fact. The case that we need to go to is Stonegate, which is at Authorities Bundle 4, which we're already in, I think. Tab
7 we're in.
Sorry, we're in 7, you're right. I want bundle 4. My lords, we want tab 4. Sorry, my lord. The clauses are quoted at page 313 at paragraph 13. There were 3 responding clauses. This was on what was called the RSA 4 wording in the test case.
Yeah.
Which therefore provided an embarrassment of riches on which to test causation and other things. And you'll see from paragraph 13, which is quite dense, but that it included, although it lists 2 there, one of them is a double. So it included 3 perils. One of them, and we could look at them if my lords like, it's in the appendix, but one of them is a pure disease clause, meaning it requires disease within the vicinity. And vicinity in this case was defined as everywhere. Well, it was capital V vicinity was construed in the test case as meaning everywhere in the country. So there's a pure disease clause, and then there were also 2 non-damage DOA type clauses, prevention of access clauses. And why are there only 2 listed in paragraph 13? Well, because slightly strangely, the definition of notifiable diseases and other incidents itself included both the pure disease but also a further prevention of access provision. If my lords need to see it, it's at 37728. It probably doesn't matter, other than that the flavour of it being a pure disease clause may have affected some of the reasoning. And if we go then to page 365, my lord can see at 253 the savings clause after less. So it sees 365 paragraph 253. It's a seesaw reduce wording. And then the issues were set out at 255. Paragraph 256, that grounds 2 and 3 in our case were not considered because of a concession, which was to be reversed at the Court of Appeal, but that settled. And so the sole issue here was the seesaw reduce point, our
Well, they're
ground.
going to ask to reverse it. They're going to ask the Court of Appeal.
That's right, my
to
lord.
withdraw the concession.
Yes,
Court of Appeal might or might not.
it might or might not. My lord's right.
Might have said you
It's stuck.
stuck to your guns in a particular direction.
Absolutely, my lord. But
258.
yes. So 257 sole issue. 258 is the reasoning. Sorry, the summary of the conclusion. The reasoning follows, which we'll go to. Costs were reduced pro tanto because the net financial effect and the commercial reality. And then the reasoning of 3 further considerations you see from 259 onwards. First at 259 is accounting treatment. And my lord, you'll see in the summary at 260, the primary accounting treatment in the UK has the grants accounted for as other income. By which I mean if you follow the UK GAAP or the IAS, then it's mandatory to not net off the wages from the grants. There's a specific provisions about grants. This is not just a general accounting provision. So the wages line in the accounts remains as a cost still incurred, unreduced, and there's an income line added for the grants. It's other income because it's outside the main business. My lord, just
The
brief.
judge only relied on it
Yeah.
to, as he put it, because it enhanced the reality of the lack of reality of the insured's position.
That
He cites the passage from Riley where Riley says it would seem inappropriate for the disclosure income classification required in sets of accounts to dictate the indemnity provided by the policy. So one doesn't really get much from that point, does
My
one?
lord, one doesn't get much. The point he's relying on is that under other accounting treatments, and that's other than used by these insureds and other than used by the UK system, one can net them off.
Yeah.
The point that we would, well, we agree with insurers that it's irrelevant. But we think that my lord, Miss Justice Butcher did take something from it because he says it highlights the unreality. We say the contrary. If there's any unreality highlighted, it's the unreality of the insurer's position. Because under the UK accounting treatment, the mandatory treatment, if you are to net off the expenses from the grant, you are not providing a true and fair representation of your financial activity. Of course, you have to log both, and anyone reading them will see that there's an overall effect that you're no worse off. But as a matter of commercial reality important to businesses, an expense is not the same as an income.
Well, those responsible for US GAAP and the International Financial Reporting Standards would disagree.
They disagree. They give you the option. They say you can do it either way.
So to assert it as if it is a given seems to me to put it too high.
Well, the judge, that's exactly the point the judge is really making, isn't it?
Yeah, the judge is saying if you can do it by some
accounting standards
Yeah.
say you do it that way, some
Yeah.
accounting standards say you don't.
Yeah.
And the most that the judge takes from that is, well, you get some support from the fact that some accounting standards say you can do that. That is the commercial reality that matters for the purpose of this clause.
Yeah.
That's as far as the judge goes.
I think that's right, and I say the other way. But the point, my lord is right, and the ultimate point that we would make is that the question of what is true and fair for the purposes of reporting your financial activities is not the same question as the question of what ceases and reduces under a savings clause. And then if we see the reasoning at 264 to 6, this is the second. My lord there says that some CJRS was paid in advance of wages, which is true, not for my client, but is true. Obviously in the initial period that wasn't possible, but once the system was up and running, you could get funding in advance, especially where your cash flow would require that. And so you can't say that the wage costs hadn't reduced. Now we say that can't be right, that matters. Just because the funding comes in before the wages, rather than reimbursing afterwards, doesn't affect whether the wages are reduced, because the funding is either separate or not. It's if one takes the view that there's an overall netting, then no one's better off either way. And if one accepts my case, which is that the cost is the key thing, and you don't look at how it's funded, then if anything it helps us, because it highlights that all the government is doing is funding an expense.
In that situation, does a grant give rise to a quis-closed trust? Suppose that the wages have not yet been paid, the government makes the grant, the employer then becomes insolvent, and the employee says, I have a preferential claim in insolvency to the sums you've received from the government in respect of my wages, because they were paid for a particular purpose, namely to be paid to me for my wages. I wonder whether that's arisen in relation to any insolvencies. It wouldn't surprise me.
I've never heard of it, my lord. I think the argument would be the government saying that you were holding it until you pay the wages. And
the argument would rise in the insolvency. Suppose
yes,
it's not enough,
my lord, that's right.
and the employee simply says, I have a preferential claim because there's a quis-closed trust in relation to that. It was paid, it was hypothecated essentially to my wages, and I have a trust interest in it, which beats the general body of creditors.
That would be a very interesting case for us to argue. I think if you look at the Treasury direction provisions, there's quite a good case for saying that's not how it works, because the government allows for the fact that you have to pay it for a particular purpose, but if you don't, you should pay it back, and there are provisions about that, which you might think excludes, because they don't provide for any property consequences. There's no retention of title.
The fact that you have to pay it back if you don't use it for that purpose might support a quis-closed trust. But I don't mean this to be an exam
Yes.
question for you.
Yes,
For this
my lord.
reason, because
That's a relief.
it wouldn't at all surprise me if in the course of COVID that issue had not arisen in some insolvency proceedings.
I don't think.
Anyway, I don't know whether that's been the subject matter of any research, but if it hasn't, it might potentially be relevant.
Well, on that last point, I can't see how it's the test for whether the purpose is sufficiently concrete and the intention is construed as preserving title separately from the mixed assets is not the same question as whether the expense ceases or reduces, because as between the payer and the payee, the expense remains, and it's just a function of how well protected the funding of that expense is or is not.
No, I can see it may not be determinative, but it might give greater weight to what Mr. Justice Butcher here was saying.
Yeah.
If the furlough payment were effectively hypothecated in this situation to paying that particular employee.
Well, my lord, if I might just park that for now. If Mr. Scory wants to explore critical illness trusts, and we will obviously think about it overnight, but
Well,
I do.
perhaps those who
Yes,
don't have other things to do, which of course they will do,
My lord.
might at least look into that, because
yes.
we have to try and get the right answer, and it might at least inform.
Might help.
Mr. Day loves an insolvency problem, my lord. But I do resist the suggestion that it's of any real weight here, because even if it were, and what I've done there is failed to move on from the point. But even if it was hypothecated, as my lord says, that's just a question of the funds being preserved in order to ensure that they're not kept by the insured if the wages aren't spent. And there's no requirement that the very same money is used, as is witnessed from the fact that normally it's a reimbursement. So it really doesn't create a new link between the expense, which we accept is the purpose of the funding in the sense that it must match it. But there's no suggestion, even where it's funded, that one has to use the same money, etc. So I don't myself on my feet think it helps either way, but we will take it away. My lord, the third point is, sorry, there's also, yeah, the third point is further down, which is at 267 to 270, 269, and that's should you lean towards indemnity, and that's a reliance on synergy. And in 269, my lord, Justice Butcher considers that the approach in that case should be adopted here, and that otherwise there's more than indemnity, and we say wherever you're talking about more than indemnity, you've probably gone wrong, because you just need to apply the formula, because as my lord the Chancellor says, the policy will always provide for more or less than an indemnity, and instead of providing for an indemnity, what the policy does is it provides a formula that is the indemnity that the parties have agreed upon. So we say that we shouldn't be straining, and that my lord got it wrong there because he departed from the words, and with respect, the reason that he was leaning to the synergy point is we say an implicit acceptance that there's a bit of straining going on because the natural meaning of seesaw reduced doesn't apply. So we say absent the straining, well, you're just stuck with those words. Other case law, my lord, there's the hyper trust case, which is, we touched on in our skeleton paragraph 21. We'll see whether my learned friend relies on that.
The Irish case.
It's the Irish case. Perhaps I should turn it up. It's at Authorities tab, Authorities Bundle 3. And it's at tab 37. Tab 37. I'm gonna have to jump around slightly to show you how this came about. If you first go to page 963, I'll come back to this, but I just want to show you how the argument arises or doesn't arise. You go to 963 at paragraph 46, you'll see a reference to the arguments made in Stonegate about seesaw reduce, and the penultimate sentence on that page says it should be noted a similar argument had been made at one point by the plaintiffs in these proceedings, but was not ultimately pursued. And then if you go to paragraph 8, which is on page 939, you'll see that the case had settled, so the parties agreed on almost everything. Including that furlough was to be deducted. Sorry, not furlough, the Irish equivalent. Was it TWPP? TWSS. So there was no adversarial argument apart from on one point. And then if you go to paragraph 50, which is at page 966, and 51, you'll see that although without adverse argument, the judge reaches the conclusion that Mr. Justice Butcher is right and the savings clause does include funding or reimbursement. Although in paragraph 51, the judge is very keen to say that he doesn't rely on the general indemnity principle. And then, perhaps slightly bizarrely, if one goes to paragraph 54, page 969, you see that the only difference between the parties is whether the conclusion that the grants were to be deducted, which the parties agreed on, could be in part justified by a reliance on the indemnity principle. And that provided a license for the court at paragraphs 52 through to 72 to conduct an adversarially argued investigation of whether the indemnity principle provides help here, including consideration of the synergy decision. And I don't think my lord needs to read that, but it concludes at paragraph 72 that we should be wary about indemnity principle arguments and just look at the formula, although in that case they thought the formula was against the insureds. So we say it's of no persuasive value because it wasn't argued after a settlement. The point was conceded, the points that matter to us, and it doesn't add anything to Stonegate. Finally, on cases, my lord, there's Mr. Justice Jacobs' decision. So that's at the core bundle. Which is at tab A, so before the remainder of that bundle.
Yeah.
And the numbering started with A's, and it's at A.92, that's the page.
Yeah.
My lord, one general point there, which I think refers back to a comment that was made, is it's at paragraph 435. This is the question of whether if the insurers cannot rely on the savings clause, they can rely on anything else. And the answer that Mr. Justice Jacobs gave was no. And that derives from the same conclusion being reached in Stonegate. And indeed is agreed here, but you'll see from my flicking that I'm trying to give you the references. I'll give you that in a minute when I find it. But the insurers agree that in this case as well. My lord, you'll see the reasoning there is quite short. 436, my lord says it's the same issue as Mr. Justice Butcher, and he's not persuaded that he's clearly wrong. Indeed, he thinks he was right. And he relies just in passing on hypertrust. And paragraph 437, he says, I don't think the attack that I levied there and do now also on the leaning towards an overall indemnity is a significant point. And he says in 438, well, that's because that wasn't critical to Miss Justice Butcher's analysis anyway. And in 439, he says, in any case, I'm applying English law, as did Mr. Justice Butcher. And so he seems to be reading Synergy and then Stonegate as confirming that there is some English principle of construction that one has to lean in a particular way, and he's bound by that. And 440, that's the end of that. So Mr. Justice Jacobs, although he confirms that he agrees with Mr. Justice Butcher, he doesn't really give additional reasoning, and it doesn't add much to the body of our learning, other than to confirm that his reaction on construction was the same as Mr. Justice Butcher. So he doesn't touch on the meaning of cease or reduce or counting issues, etc., because essentially he found himself bound by Stonegate, and my lords will recall that on causation, similarly, because he was bound, he didn't even reason on that issue because the insurers agreed to judgment against them subject to appeal. My lord, on ground one then, to conclude, we say that the plain words of the savings clause, and we have to start with those words, indicate that there was no saving here because the wages were incurred in full. The expense was paid in full. They were not reduced and they did not cease. We say those plain words are clear and they have an obvious application in use, which has been the case for many years, including electricity charges where there's no factory in wages where some staff have been made redundant, and all sorts of other expenses. And that's what they deal with within the formula that the parties provide. And there's no indication in any case law or commentary that anyone saw them as having a broader commercial sense that allowed one to go outside the question of whether between the payer and the payee, essentially the money passed. We say that conclusion is supported by the structure and the formula of the policy because incomes are dealt with by various provisions and they do not include these grants. Costs are dealt with by separate provisions, including the savings clause. And that the netting off that is allowed is that mandated by the policy. It's between the different costs and revenues, not within any definitions of the different parts of the policy. Indeed, the insurer's approach would be arbitrary because it would say that the incomes, they'd accept that grants are excluded unless they're revenue, which they're not. But if they happen to have matched an expense, then they are included by virtue of the savings clause. Now, of course, if that's the meaning of the savings clause, that's the meaning of the savings clause, but we rely on the reasoning in Princess Theatre that that is not the meaning of the savings clause, which, if one steps back and looks at it clearly, just asks about the charges and expenses, which means what money was paid for what, we say, my lord. And we say, therefore, Mr. Justice Butcher and Mr. Justice Jacobs fell into error. And that is what I wanted to say about ground one. My lord, ground three, which is asked...
Just before you leave,
yes, of course.
can I ask you just a point that's troubling me? I don't know whether it's of any importance. Back to the policy.
Yes.
Page 63, condition 21.
Yes.
Which is an amendment to the definition of estimated gross revenue. Is that right?
Yes.
And as one would expect, when we get to the estimated gross revenue definition, it's a definition of income, revenue, rather than cost. I just wondered how hospitality costs, CVH costs, prize money and race day savings come into estimated gross revenue at all as costs.
My lord, I've managed to resist so far, but I'm gonna hand up that spreadsheet that, I think it's easier to see that way, that we talked about last week. If there's an usher, quick ush. I'm not going back to any limits points, but this is the declaration sheet that we referred to. It's the wrong year. Sorry, my lord.
It's the wrong year.
It's the wrong year. We explored this a little bit in trial. No one could find the right year, but it's not disputed that something like this was used. It's not a very profound point. I don't think it will be controversial, but I think it's better to illustrate using numbers.
Right.
So,
What do you want to look?
it's only really the top line in the box. So when the parties were setting out, and my Lord Justice Popplewell is absolutely right that there's a bit of illogicality about this, but it's the way these things work. If you're insuring on a gross profit basis, and as I say, to some extent, that's what this clause does.
This isn't concerned with gross profit.
No, it's not. But the gross revenue figures exclude these costs. They're treated as savings because they will cease in the event the racing does not take place. It says at the very top. And what I understand that means, I can't go beyond what I'm about to say, and if my lord say, oh, I don't understand that, or you must be wrong, well, that's another matter. But the parties, rather than insuring those expenses and having their full gross revenue figures, they deducted from their revenue figures those costs amounts on the basis that they were themselves applying a savings approach, which is like a gross profit policy, and therefore they were insuring the lower amount, allowing for those savings. And that's why the parties say that a cost is excluded from a definition of gross revenue.
Hang on, yeah, okay, so, because it was gross revenue rather than net revenue, as it were.
Yes, so they had to add their own
They
netting.
would obviously reduce the gross revenue. And so what it's saying is, although you would normally take those into account, you don't, because
We've already uninsured them.
well, actually, they've already been taken into account as savings, effectively.
Yes.
Okay.
So the amount of those costs,
So it's
because
actually,
a profit.
frankly, it's a non-point, isn't it, condition 21?
Well, it's a non. It doesn't matter to this claim, no. But it's a point that merely shows how the parties are defining in and out
And
of
if
costs.
hospitality costs, the costs that the racecourse would have incurred in, or dog tracks particularly used to incur in producing dinner, etc. That's no longer an expense that's incurred. Well, that's within the savings clause. It's a matter of, if leaving this to one side, you tell you that's.
It would be, and they say at the top, they're inevitably going to be savings, but what they don't want.
But you take that's taken out of the equation because it on condition 21 never actually comes into the equation effectively.
Exactly. It's in order to reduce your declared sum insured and therefore reduce your premium, where you're inevitably going to have savings. You say, I'm going to ignore that part of my revenue because I know I've got savings of the same amount. So let's reduce, and therefore I'm only insuring the lower amount. So it's a netting off done by the parties.
Yeah.
Thank you.
Could I just ask you one other thing? As I understand the scheme, there was also a reimbursement of employer national insurance
Yes, my lord.
contributions. Now, you presumably would accept that is a reduction.
It was paid by, you'd have to go into which part of the treasury, etc. But it was paid to the business, and then the business still incurred the national insurance expense on behalf of the employee to the HMRC.
I thought you'd said that where the government rebates a payment to the government, that is a reduction.
Well, we'd have to look at which bit of the government. Is it the same?
Insurance is presumably paid to the Treasury, is it?
It's paid to His Majesty's Revenue and Customs. Is that a separate entity?
Yeah.
I assume so, but ultimately the Treasury. And if it were the same, then you'd have to look at the nature. I'm a bit rusty on my PAYE, how it works, but the employer is, I think, paying an expense on behalf of the employee there, but it's still paying it, and then it's funded by money coming the other way. But let me go away and think about that, my lord, because I totally see my lord's point.
Well, and just to develop it, obviously it would be very strange if part of the payment was a saving and part of it wasn't.
I don't think so, my lord. The business rates relief. So if this were effectively a relief in that the the national insurance payment is no longer charged, it's just that for convenience you still pay it and we pay you back the same amount. If it was the same entities and that was what was happening, then you might say that, well, that's different because it's a relief like business rates relief. So one could reach the conclusion that you separate out national insurance. I don't think that impinges on the wages at all, which are clearly payable to the employee. But I'd like to think about that a little bit more and maybe come back to you after lunch or in reply.
Right.
My lord, yes, so just to start on ground 3, which is our skeleton 68 to end, the question is, if the wages did cease or reduce, and only if that's the case, was this as a consequence of the peril? And we think it's agreed that as a consequence of includes a proximate cause test. That was the purposes of it. If I show you, one commentator identifies this at Authorities 3, tab 50. My lord, it's at 1286. I'm not saying this is admissible like it's Hansard or something about
It's just a textbook, isn't it?
it's just a textbook, but the explanation given in 1286 is that after Polikov, and I showed you that case where the insured had paid down their mortgage expenses using the proceeds of a material damage policy, and it was thought that that might be collateral as a matter of causation, but there's nothing in the clause that deals with that. It said that the words "in consequence of the incident" were added to the ABI gross profit form. And in any case, my learned friend and the court engages with the question as one of proximate causation, so I don't think that's in dispute that "in consequence of" must mean that. So
This doesn't say it's proximate causation, it
No, no.
says it's introduced to provide
Yes.
some causative link.
yes,
Causative link,
absolutely.
not dealing with whether it's proximate cause.
No,
Where is the agreement that that's the effect?
well, let me think about that, but we all talk about the same cases because we've all,
Well, it may be quite important.
Yes.
Whether in consequence
let's see if
of
that's agreed.
means proximate cause, but some importance for other cases. And
Yes.
there's quite a lot of authority on it.
Well, so the long way,
Forms of wording,
yes,
do
my
or
lord.
don't.
So the long way round
involve
was
proximate cause.
in the test case. It said that words probably mean proximate cause unless they don't. Of course, they may still not, and there were some words where it was thought they might not. So in result of obviously would, but others that following
Following, for
may
example,
not,
in this clause, may
Yes.
well not.
may well not.
No.
I can't remember whether in consequence of was used there.
Yes, it's paragraph 165 in the FCA Supreme Court.
So we want the FCA Supreme Court judgment, which is tab bundle
Volume 4.
bundle 4.
Tab 3.
Tab 3, page 258. Sorry, yeah. Starts at 257, yes, the many formulations. And in some of those, within the peril, the words "in consequence of" were used. And the conclusion was that there was nothing special to say about "in consequence of." An approximate cause test was then applied to the QB 2 and 3 wordings, which may be why my learned friend doesn't dispute the points. Or it may be why I thought he didn't. And it's not laziness that suggests that as well. There's a symmetry, because of course the indemnity is where the interruption or interference was in consequence of, and therefore the reduction in turnover was in consequence of, and similarly you want the savings to have been in consequence of the peril as well. Otherwise they're out with the indemnity that's agreed. So that's how we came to that question. And yeah, my learned friend says at paragraph 50.5 of his skeleton that talks about what's approximate cause of the introduction of CJRS, but we can leave the particular passing.
Yeah.
So, and that's why one engages the questions of legal causation and collaterality. And perhaps before we get into the weeds of that, if we just look at the principle overall, and then we might be time, my lord, if we briefly go back to the Lowick Roads case for a slightly different point. So that's authorities tab 2.
Tab 2 or bundle 2?
Sorry, bundle 2, yes. Bundle 2, tab 26.
Yeah.
And there, if you look at page 424, paragraph 11,
Yeah.
you'll see there's a summary of the principle as it applies in collateral payments generally. And then from "in spite of" at line 4 on page 425, you see, well, never mind about the Latin tag, it's about the source, it's the character of the benefit. And then collateral benefits are those whose receipt arose independently of the circumstances giving rise to loss. And the familiar legal causation language of res inter alios acta and collaterality. So it's legal causation, but within the context of the collateral payment cases on legal causation. That doesn't mean that the same answer is reached in a tort case about personal injury, because it's got to be causation between the particular here peril or their wrong and the benefit in the particular context. But it does mean those cases are informative. And I think finally on the overall principle, it's not going to take us very far other than some of the conclusions that Mr. Justice Butcher and relied upon by my learned friend reaches seem to suggest that the burden falls on the claimant to show that a government payment isn't intended to be taken into account. I would just refer you to the Asset Co case, which is in that same bundle 2, and it's at tab 28, this is a professional negligence case, and it's at page 528. And we see at paragraph 230 through to 232, particularly you see the last sentence of 230 onwards. It had been argued that a benefit which is caused by the wrong factually is a benefit, i.e. is taken into account, unless it's collateral or res intralius acta. And that's rejected. And you see first sentence of 231 and then second sentence of 232. You see in 232, before credit's given, it must be shown to have been legally caused by the breach. Now, my lord, it's not in your bundles, but the Supreme Court in Sainsbury's said the same thing, that the burden's on the defendant to show that the benefit decreases the loss. I can hand that up if my lord's like. My learned friend knows I brought it with, but probably not necessary. The claimant has to show that the loss that they're seeking was legally caused, but where there's a benefit that's been received, the defendant has to show that that was legally caused. Now, not much is going to turn on burdens. We have the facts here, but there is the suggestion that the cases indicate that wherever there's a payment from a third party, including a public authority, that unless the claimant can show that the intention was not to benefit the insurers, that the payment needs to be taken into account. And we say, well, that's wrong, partly when we analyse the case law, but also from the overall burden on the legal causation question. My lord, do you want to press on for 4 more minutes into the cases? So we say, my lord, as Mr. Justice Jacobs put it, which is, we don't need to go there, but it's at paragraph 455. He said the question is whether CJRS can be equated with benevolent gifts. Now, benevolent gifts is not the test, and we're not suggesting that it is, but he is correctly identifying that the question is in the Parry and Cleaver territory of, was this payment collateral? And we think it's accepted. We give the example at paragraph 70 of the wealthy horse lover who steps in to fund the wages bill because they love their local racecourse and all the people who've served them drinks there. And maybe their leg has been doing well. And we say, well, that's obviously, and we don't think the insurers would disagree, even if that is a cease or reduce, so it is a saving, we say it's obviously collateral because it's a benevolent gift by a third party. And that's whether or not, and it's unlikely that they did, whether or not they said, oh, if you've got insurance, I don't want your insurance cover to be reduced. It's just the nature of the benevolence, which is that it's to benefit the insured. And if anyone's to get an additional amount out of it, it should be. So there's no argument that there's a windfall problem there. The insured is allowed to keep the gift and keep the insurance payout. So, my lord, turning to the cases, if we go to our skeleton.
Well, let's do that at 2 o'clock.
Let's do that at 2 o'clock, yes, ma'am.
Court rise.